Andre Thomas, have you had a chance to talk to, sufficient time to talk to Mr. Turner as to whether or not he, one, chooses to testify as a witness on his own behalf, and whether he wants the court to consider charging lesser included offenses that would not be covered by the statute of limitations normally?
Yes, sir. The first request, he will not be testifying, and if the court wants to voir dire him on his choice, he's available for that. And on the second, we are going to waive any objection to statute of limitations issue.
Would you like to conduct that moment voir dire?
Yes, sir.
Mr. Turner, come around, please, sir. Come around to your left. Mr. Turner, good morning. Good morning. Raise your right hand, please, sir. Do you solemnly swear or affirm that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, Mr. Turner. Yeah, now have a seat right here, sir. Right step, please. Mr. Turner, good morning. If you will, please state your name for the record and spell it for the court reporter, please, sir.
Billy Turner, Billy Turner.
Mr. Turner, this is what is referred to as a Momon Hearing, okay? Mr. Perry and or Mr. Thomas are going to ask you some questions about whether or not you choose to testify as a witness in the case. You understand that, sir?
Yes, sir.
Prosecutors will not be able to ask you any questions at all. Mr. Perry is not going to ask you anything about what happened, and Mr. Thomas will not ask you anything about what happened, what you did, or what you did not do. They will not ask you those questions at all. So listen to the questions that Mr. Perry will ask of you. Make sure you answer those questions. Don't volunteer anything. Don't say anything about what might have happened. You understand that?
Yes, sir.
You have any questions, sir?
No, sir.
Mr. Perry, you may proceed.
Thank you, John.
Yes, sir.
Mr. Turner, please, you've been here throughout the full week of trial, correct?
Yes, sir.
And at all critical moments, you've been present in the courtroom, right?
Yes, sir.
As well, we've had conversations regarding the right to testify.
Yes, sir.
And you also know that you have a right to not testify.
Yes, sir.
Based on our conversations and the representations of counsel, the advice of counsel, have you made a decision regarding testifying?
Yes.
What's your decision, sir?
I do not want to testify.
All right. And you ready to go forward with the case?
Yes, sir.
Do you have any? Do I need to ask him anything additional, Your Honor?
No, sir.
All right. Thank
Mr. Turner, what Mr. Perry just told you is that this is your right. You understand that, sir?
Yes, sir.
This is 100% your choice. You understand that?
Yes, sir.
Now, what Mr. Perry has told you and what Mr. Andre Thomas has told you is that, well, two things. Let me cover two things. Back up a little bit. Nobody can call you as a witness. You understand that?
Yes.
I think you ever tell the jury that on Monday. Nobody can call you as a witness. Nobody can prevent you from testifying. Mr. John Keith Perry, Mr. Andre Thomas will give you advice, give you opinion as to whether or not they think it might be a good idea or a bad idea.
Yes, sir.
They'll cover those things that could be possibly good for you, some things that could possibly be bad for you, the advantages and disadvantages of testifying or not. You understand that?
Yes, sir.
Their advice does not control what you do. You understand that?
Yes, sir.
If you tell me that Judge Coffey, I want to testify, you'll be allowed to testify. If you tell me that Judge Coffey, I made this decision, it's a personal decision, not what your lawyers want to do, but what you want to do. You made a personal decision to remain silent and not testify in this trial. That is 100% your decision. You understand that?
Yes, sir.
Mr. Turner, if you made a decision to testify, I would tell that jury, they will look at, they will evaluate your testimony just as they would any other witness. You understand that, sir?
Yes, sir.
If you made a decision to remain silent and not say a word, I would tell that jury they cannot hold it against you for any reason at all. They cannot draw any inferences from the fact that you chose to testify, and they cannot think or even speculate as to why you made the decision to remain silent. You understand that?
Yes, sir.
And this is 100% your decision. You understand that?
Yes, sir.
And actually, that was Turner, because in almost 16 years of trying cases, people sat in that witness stand and they tell me, Judge Coffey, I decided not to testify, or Judge, I decided to testify. Then they'll come back a week later, a month later, a year later and say, Judge Coffey, I really wanted to testify. My lawyer would not let me testify, so I really wanted to testify, but I didn't because my lawyer would not let me. So this is your decision. You understand that?
Yes, sir.
Now, you're telling the court, you told Mr. Perry that you have made the decision not to testify. Has anybody threatened you, promised anything, put any force or pressure on you in order to get you to make that decision, Mr. Billy Turner?
No, sir.
You have any questions you want to ask the court, sir?
No, sir.
Mr. Turner, I know you told me you couldn't wait to get your day of trial. I'm glad we were able to try this case for you this week, sir.
Yes, sir.
Thank you, sir. You sit down. I wish you good luck in the rest of the trial, sir. And for the record, pursuant to Momon Momon versus State, 18 Southwest 3rd, page 152. A 1999 Tennessee Supreme Court opinion, I find for the record that Mr. Billy Turner understands that he has the right to testify or not. Mr. Turner understands that this is 1% his personal decision. I find that Mr. Perry and Mr. Thomas have advised Mr. Turner about the possible benefits, the advantages, the disadvantages, the good, the bad that could result in his making a decision to testify or not. And I found that Mr. Turner has personally, knowingly, voluntarily waived his right to testify and present evidence on his own behalf. And I will in fact charge the jury that Mr. Turner is presumed to be innocent of these charges against him, that he's not required to take the stand on his own behalf, and his election not to testify cannot be considered for any purpose against him, nor can any inference be drawn from the fact that he chose to remain silent and not testify in this case. Mr. Turner, stand up for a second. I apologize to you, sir. Come back, take the witness stand for a second again. I need to ask you some other questions on other issues, and I apologize for not taking care of that when you were on the stand a minute ago. You can have a seat, Mr. Turner. You're still under oath, and I apologize to you for having to call you back to the witness stand. But before we took a break, I talked to you about the statute of limitations, and that's a lot of words. And what it means, Mr. Turner, is that in order to be prosecuted for certain crimes, the state of Tennessee has to initiate the prosecution within a certain number of years. This conduct occurred allegedly back in 2010. And for a Class A felony, the state has 15 years to initiate the prosecution. So those Class A felonies, murder, attempted murder, conspiracy, those are included within the statute of limitations. You understand that?
Yes, sir.
B felonies, there are 8-year statute of limitations. There are some other included offenses that the court could charge, and will charge if you tell them it's okay with you. Class C and D felonies, that prosecution has to be commenced within 4 years. On an E felony, it's 2 years. Now, on any misdemeanors, it's 12 months. I think it said 11 months to 29 days. It's just a year, 12 months in Tennessee.
Yes.
In order for me to charge those crimes, lesser crimes, to get a jury the option, if they find that you're not guilty of the greater crimes, they can be given other options about lesser crimes. For instance, on the first-degree murder, necessarily included under Tennessee law for first-degree murder would be the included offenses of second-degree murder, which is a Class A felony. Also, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, which is a Class C felony, facilitation of voluntary manslaughter, that's a D felony, reckless homicide is a D felony, criminally negligent homicide is an E felony. All of those included offenses, anything less than a B felony, I cannot charge the jury on that. They cannot consider it. You understand that?
Yes, sir.
The only way I can charge the jury on that, Mr. Turner, is if you tell me that, Judge Coffey, I am waiving the statute of limitations. I want you to charge all possible included offenses on all counts of the indictment, and it gives the jury a greater range of options as to offenses they can consider. But I can do that only if you tell me it's okay. You understand that, sir?
Yes, sir.
And are you asking the court to waive the statute of limitations for C, D, E felonies, possibly misdemeanors, and charge everything that could possibly be included in your case?
Yes, sir.
And have you talked to Mr. John Keith Perry and Mr. Andre Thomas about that?
Yes, sir.
You have any questions about that? Because I know it's a lot of legal words. You have any questions about it?
No, sir.
And is this also what you want to do?
Yes, sir.
Has anyone threatened you, promised anything, put any force or pressure on you in order to get you to make that decision?
No, sir.
You have any questions about the court, about the statute of limitations or those included offenses?
No, sir.
Thank you, Mr. Turner. Step down again. I apologize, sir.
All right.
And this court will find pursuant to State versus Pearson, Pearson, 858 Southwest 2nd, page 879. This is a 1993 Tennessee Supreme Court opinion that dealt with the issues of lesser included offenses and statute of limitations. Supreme Court in the state of Tennessee has held that the statute of limitations is waivable, that it is waivable because it is not jurisdictional. But in order for the court to charge those lesser included offenses, anything less than a B felony, C felonies, D felonies, Class E felonies, the court has to find that Mr. Billy Turner has knowingly and voluntarily waived his right to have the jury to consider those offenses which in fact would fall outside of the statute of limitations. And again, for C and D felonies, statute of limitations would be 4 years, for an E felony, 2 years, for a misdemeanor, 12 months. And this court has conducted a hearing according to the Pearson case and made sure that Mr. Turner has been advised of his rights to say, Judge Coffey, I do not want the jury to consider those lesser offenses, and if I don't have this hearing, if I charge those offenses and the jury comes back with a verdict on some lesser charges, the Pearson case and other cases would say that it is a void conviction because there's nothing on the record that would indicate that Mr. Turner was advised of and apprised of the statute of limitations and the consequences of waiving that statute of limitation. This has been intelligently and knowingly waived by Mr. Turner because it is possibly in his benefit, and he has made the decision after consulting with the counsel, and it does not contravene rather public purpose and the purpose of the statutes to allow Mr. Turner to say, Judge Coffey, I'm willing to waive the statute of limitation on lesser charges, and it gives the jury a wider range of options that they can consider if a jury finds me guilty of any conduct, and I'm not presupposing that a jury will convict Mr. Turner of anything, but I'm finding that he's waived the statute of limitations, and I will in fact charge all possible lesser included offenses on all 3 counts of the indictment. Your next witness, Mr. Perry or Mr. Thomas, will be if you choose to present any additional proof.
Yes, Your Honor. Ms. Jennifer Bogan.
Yes, sir. Are both sides ready to proceed?
Yes, sir.
Deputy Smith.
Yes, sir.
Bring in the jury, please, sir.
Yes, sir.